mark your calendars, folks. We have a lot of big dates coming up this fall involving your Second Amendment rights. So to help you track some of this the way I track it, I'm going to go through some of the big dates that I've got circled on my calendar so you too can track our right to keep and bear arms in the court system. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Box and Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the detailed account of how I think the anti-gunners are going to try to take away our rights bit by bit. Extreme detail. I lay it all out in First They Came for the Gunners. Check out a copy. It's also available on Audible and on Kindle if you're interested in those formats. All right, folks. So we got some big dates coming up involving the Second Amendment. These are just the ones that I think you can mark your calendar for. There's obviously going to be a lot more involving the Second Amendment than what I'm about to describe in this video, but I want you to at least understand what is coming down the chessboard over the next 4 to 5 months. Some of the highlights. The first one, of course, is on September 7th. That's this week. Specifically, the Vanderstock versus Garland case dealing with the quote-unquote ghost gun rule of Joe Biden's. This is the unfinished frame and receiver rule. Ghost guns, of course, is a propaganda term for unserialized firearms. And as we've talked about repeatedly, the definition of firearms talks about frames and receivers, but it doesn't talk about parts of frames and receivers. We're in a very unusual circumstance there because the Fifth Circuit Court of Appeals out of Texas and Louisiana in the Vanderstock versus Garland case specifically said that the ATF had exceeded its authority and was unconstitutionally acting, and therefore it was enjoined. But then the Department of Justice sought an emergency stay of the Fifth Circuit ruling, and the United States Supreme Court enjoined or stayed the Fifth Circuit ruling. So you got this weird dynamic where on September 7th, the Vanderstock case is being argued to the Fifth Circuit that has already basically found that the ATF has exceeded its authority by expanding the definition of firearm to include parts of frames and receivers as opposed to just frames and receivers. But at the same time, the U.S. Supreme Court, while not specifically dealing with the merits of the matter, has come out and did not allow the injunction entered against the ATF by the Fifth Circuit to stand. So you have the U.S. Supreme Court not overruling the Fifth Circuit on the merits, but basically getting rid of the remedy, the short-term remedy, which is to have enjoined the allegedly unconstitutional illegal regulation by ATF. Nevertheless, big argument on September 7th. We'll be covering that, I'm sure. I'll try to put a link to it down below and put it out on Twitter if I can get a link to the argument ahead of time. Again, the question there is, did the ATF exceed its authority in promulgating this quote-unquote ghost gun rule? The Fifth Circuit said yes. The Supreme Court kind of implied maybe it did, but again, the injunction did not stand, so the Biden administration can enforce this rule that the Fifth Circuit has said it was unconstitutional, so it's kind of a quirky situation here. That will be argued in the Fifth Circuit on September 7th, coming up in just a day or two. Now, the next big thing on my calendar is October 25th. October 25th in the state of New Jersey, specifically the Third Circuit Court of Appeals, which is the Court of Appeals out of Delaware, New Jersey, and Pennsylvania. They are hearing the argument in the Koons versus Platkin case. Just to jog your memory, this is the big sensitive place issue. Sensitive place is a euphemism for government-mandated gun-free zones. This will be argued in the Third Circuit Court of Appeals on October 25th, 2023. Just to jog your memory, the district court in New Jersey, Judge Bum, specifically granted the plaintiff's motion for a preliminary injunction enjoining the enforcement of many of New Jersey's carriage restrictions. Just to jog your memory, after Nyserpa versus Broome was decided in June of 2022, which is a big win for the right to keep and bear arms, places like New Jersey and New York threw a little hissy fit, and came out and said things like, oh, we're going to make everything a sensitive place, which, by the way, I predicted before the Broome decision came out that is exactly what the anti-gunners were going to do. No shock there. It was clear where they were going to go, and that is where they went. Nevertheless, the U.S. District Court judge in New Jersey, Judge Bum, specifically basically prevented New Jersey from enforcing a lot of those laws, which was a big win for us. But again, that is now being argued in front of the Court of Appeals for the Third Circuit in the Koons versus Platkin case on October 25th, 2023. So make sure you mark your calendar for that argument. Then we have another argument Though we don't have the exact date, but I believe the week of November 6th, 2023, the case of Reese versus the ATF. This is going to be argued again out of Texas and Louisiana in the Fifth Circuit. This is a very interesting question, and I think a slam dunk for the home team, meaning us. This is a case where the plaintiff sued, brought a civil lawsuit challenging the federal ban on the sale of handguns and handgun ammunition to adults who are under the age of 21 on the grounds that it violates the Second Amendment. Now, the Western District of Louisiana District Court granted the defendants, meaning the government's, motion to dismiss, saying that the plaintiffs have failed to state a claim. But I think this is a slam dunk for us because it's pretty clear that if you look at the text of the Second Amendment, the right of the people to keep and bear arms, the people certainly include those that are 18 years and over, the most basic rule of which, and remember, the burden is on the government. The burden is on the government to justify any such gun control law because the text of the Second Amendment, the right of the people to keep and bear arms, is clearly implicated if you tell 18 to 20-year-olds they are not able to acquire handguns, which is undeniably their right to possess, because the U.S. Supreme Court in 2008 in Heller says that Americans have a right to have handguns in their home, loaded and unlocked, ready for self-defense. So therefore, Americans, i.e. people, i.e. the right of the people to keep and bear arms, certainly have the right to have handguns in their home. That's what the Heller case said. The only question is, do 18, 19, and 20-year-olds have that right? It seems pretty clear they do, notwithstanding the fact you have a constitutional amendment that talks about 18 to 20-year-olds being able to vote. But beyond that, just from an originalist point of view, obviously the text is implicated, which means the burden shifts to the government to show there's a historical analog law that says that 18 to 20-year-olds had no gun rights at the time of the founding. This is simply impossible to do, as I see it, for many reasons. The most obvious one is, remember, the Second Amendment was adopted and ratified in the year of our Lord 1791. And what happened in the year of our Lord 1792? The answer is that Congress adopted the Militia Act of 1792. In the Militia Act of 1792, it specifically says that those individuals between the ages of 18 and 45 have a duty to bring with them to militia musters guns, ammunition, black powder, pouches, and so on that they themselves own. Did you hear what I just said? So how is it possible that 18 to 20-year-olds are required to bring with them to militia duty under the Militia Act of 1791 enacted by Congress, firearms, ammunition, black powder, and the like, if they don't have a right to acquire it in the first place? It simply makes no sense. It's impossible, because to them to even honor their obligations to the militia, they have to be able to buy their own privately owned firearms, which obviously means they have the right. So again, at the end of the day, the government bears the burden to show that they did not have the right. I think that's impossible for, among other reasons, the Militia Act of 1792, which cuts entirely in our way. But again, argue in Reese versus ATF the week of November 6th. I don't know the exact date. I'll put it out on Twitter as soon as I see it. But right now, it's just the week of November 6th, according to my notes. Next thing is on November 8th, 2023. November 8th, 2023. This is kind of an interesting case. This is Oakland Tactical Supply versus Howell. This is Oakland Tactical Supply versus Howell Township that arises out of the Eastern District of Michigan. In this case, the plaintiffs have brought a lawsuit because they're challenging a township regulation, specifically a zoning regulation that is prohibiting them from building a long-range shooting range within the town. The district court, which is the federal trial court, granted the defendant's motion to dismiss in favor of the government against the Second Amendment, and now Oakland Tactical Supply is bringing this appeal to the Sixth Circuit Court of Appeals, claiming that this violates their Second Amendment rights. And I think they have a strong argument because, as you know, the right to keep and bear arms presupposes we have the ability to not just acquire those guns, because we're not, born with them. We have to acquire them, which means you have the right to make your gun or to buy your gun or to inherit your gun. But beyond that, you also have the right to train with your gun. This is the famous case of Mrs. Ells out of the Seventh Circuit Court of Appeals there in Chicago that specifically says that obviously you have the right to train with your firearm so you can be proficient to the extent you want to enjoy your right to exercise your Second Amendment right, so that you're good at self-defense and so on and so on. And you can just do it for plinking and fun, of course, because it's a lawful purposes. And we have a right to keep and bear arms, not just for self-defense, but for any and all lawful purposes, including but not limited to self-defense, hunting, and so on. So in this Oakland Tactical Supply versus Howell Township, again, the Sixth Circuit Court of Appeal is going to be determining whether or not there is a Second Amendment right to build a shooting range. It seems to me that just like Americans have a right to be able to practice, you need to have a place to practice, and that would include a shooting range. So again, it'll be very interesting to see what the Sixth Circuit does there. But again, I think there's a very good chance we can win that case. And if we don't win that case in the Sixth Circuit, one wonders whether or not that'll be a good shot for certiorari to the U.S. Supreme Court, but only time will tell. But nevertheless, on November 8th, 2023, that case of Oakland Tactical Supply will be argued in the Sixth Circuit Court of Appeals. The next case you should be aware of coming up this fall, of course, is the week of November 13th. This is the case called Baughcum versus Jackson. This also involves young adults, 18 to 20-year-olds, and whether or not they have the right to keep and bear arms. We went over that basic fact, including the Militia Act of 1792, in the context of discussing, of course, the Reese case out of Louisiana. But again, in the Baughcum versus Jackson case, that is going to be argued in the 11th Circuit Court of Appeals the week of November 13th. When I find the exact date, I'll put that on Twitter and let you know. Again, I think that case, the district court dismissed the case for lack of standing. I think that's a stretch to say the least, because there seems to be standing in that case. But nevertheless, we'll see what the 11th Circuit says. That is the week of November 3rd. And of course, we cannot forget what's going on in the U.S. Supreme Court, which we've been talking quite a bit about, the United States versus Rahimi case. As we sit here right now, Mr. Rahimi's brief is due, I believe, the last week of September. So we'll be covering what Mr. Rahimi says to the U.S. Supreme Court in support of his client. That'll be very interesting, what the lawyer says in support of Mr. Rahimi. And then 7 days thereafter, I believe on October 4th, the amicus briefs to be submitted on those who support Mr. Rahimi's position to the U.S. Supreme Court, specifically really the pro-Second Amendment lawyers are going to be submitting their briefs on and around October 4th, 2023. I suspect there'll be a bunch of briefs submitted. No idea how many there will be, but I'm guessing there will be well over a dozen, but only time will tell. Again, that is October 4th. We can see the amicus briefs submitted by really the pro-Second Amendment groups, and we'll see what is said. And of course, 2 weeks after that or so, the Department of Justice in the Rahimi case gets what's known as a reply brief to try to rebut the amicus briefs of whatever Mr. Rahimi says. And last but not least, in the Rahimi case, there will be an oral argument scheduled. My guess is it will likely be in January. I think there is an outside chance that the Rahimi case could have oral argument sometime in December, but I suspect it's probably more likely been in January, but either way, it will be sometime in December or January. We will see the actual oral argument in the Rahimi case. That will be a big deal, and we may even cover that live, but again, we'll see where we are when the time comes. All right, folks, I hope this helps you give you a little sense of some of the big issues that are coming down the pike over the next many months involving the Second Amendment. Of course, there's a lot more things that we're waiting for. There's a lot of decisions that we're waiting for out of Judge Benitez in California, the Fourth Circuit involving the Maryland assault weapon ban, and so on. Right now, we're just waiting to see what these courts do, including the Second Circuit Court of Appeals out of New York, involving those 5 cases that were argued, I think, back in February or March. Still no decision there, and we don't control the courts. We can just respond to them if they issue their decisions. But I would think we're going to start seeing some of these federal court decisions coming out soon, and we'll be reporting those. But again, we don't have dates to tell you when they're coming because we simply do not know. All right. Okay, folks, hope you learned a little bit something here today about the Second Amendment and what's coming up for your rights. And again, if you haven't subscribed and liked this video, please do so. We've heard some talk about people have been unsubscribed, so make sure you subscribe. Even if you think you've subscribed, do it again. And feel free to follow me on Twitter at 4Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.